Welcome to the Animal Law Podcast. This is Marianne Sullivan, and the interview on this episode is about, quote, the most important animal rights case of the 21st century, unquote. And I am quoting that. I'm not the one who said it, though I do tend to agree. That's a quote from historian Jill Lepore writing in The Atlantic in a very recent article. And the case is, of course, about Happy the elephant, who lives in the Bronx Zoo, and on whose behalf the Non-Human Rights Project is petitioning for a writ of habeas corpus in the courts of New York State. That case is about to reach the Court of Appeals, which is the highest court in New York State. And in my interview today, Stephen Wise will be explaining exactly what they are planning on arguing and how the lower courts have been simply and alarmingly wrong about what habeas corpus actually entails. This is not the first time Steve has been on this podcast about his habeas corpus cases on behalf of animals, but this is definitely the interview that you do not want to miss. The arguments keep developing as he keeps bringing these cases, and they keep being refined, and they keep drawing pretty unbelievable support. And it is indeed the most important animal rights case of the 21st century. So before we get to that interview, I just want to mention that I hope you are also checking out the Our Hen House podcast, which I co-host along with Jasmine Singer. Jasmine's interview with Veg News senior editor Richie Bowie about, among other things, race, veganism, and media is crucial, as is my conversation with veterinarian Crystal Heath about why so many veterinarians just don't seem to get it. There are, it turns out, very real reasons why the culture in which they are educated and in which they practice turns them away from thinking seriously about animal rights. Also, don't miss flock member Sue Fisher's interview about the Thule elk, who are members of an iconic species brought back from near extinction, whose lives at a national park in California have been made a living hell by the beef and dairy industries, with the complicity of the federal government. Some interesting litigation is brewing there, which will be good to keep an eye on that for future developments. Also, please don't miss Our Hen House's 4-episode series on the podcast, setting forth the audiobook version of the new book, Anti-Racism in Animal Advocacy, which Jasmine edited and which is a collaboration among Our Hen House, Sentient Media, Lantern Publishing and Media, and Encompass. It is amazing. Don't miss it. I'll also just take a moment to ask for your support for the Animal Law Podcast and the Our Hen House podcast. If you're in a place where you can help out, please go to ourhenhouse.org/donate. There you can join our flock for $10 a month or $100 a year, or you can make a one-time donation in any amount that you are comfortable with. It's a particularly great time to do that, since from now until the end of the year, all donations will be tripled, but only if we can raise $20,000 from our listeners, and we would be so grateful if we can pull that off. All right, let's get to the interview. Stephen M. Wise is founder and president of the Non-Human Rights Project. He has practiced animal protection law for 30 years throughout the U.S. and is the author of 4 books, Rattling the Cage Toward Legal Rights for Animals, Drawing the Line, Science and the Case for Animal Rights, Though the Heavens May Fall, the landmark trial that led to the end of human slavery, and an American trilogy, Death, Slavery, and Dominion, along the banks of the Cape Fear River. He will be joining me right after this. Before we get to that interview, we are excited to share a new free resource, Animal Law Fundamentals, a product of Brooks U from the Brooks Institute. Animal Law Fundamentals is a documentary-style series of video presentations and scholarly papers on the fundamentals of animal law by some of North America's notable animal law scholars. The goal of this series is to make the fundamentals of animal law accessible to the public from premier subject matter experts. It is an orientation for anyone interested in gaining a substantive overview on an animal law subject matter quickly and effectively by listening to an academic or practicing scholar, as well as having a companion paper into which there can be a quote-unquote deep dive. The inaugural Animal Law Fundamentals presentation is by Professor Angela Fernandez on the topic of animals as property, quasi-property, or quasi-person. It is often said that there are only 2 available legal categories for non-human animals, property or person. Faced with this stark choice, judges, legislators, and members of the public will likely place them in the property category. This paper proposes an in-between quasi-hood status, quasi-property, quasi-personhood. that can be used to downplay the property-like qualities of non-human animals and augment their personhood like ones. This status can be used for a large number of non-human animals, both as individuals and at a species level, as a kind of sliding scale, as human understanding and views of non-human animals and what we owe them change over time. View the trailer, full presentation, and accompanying paper at thebrooks-institute.org/animal-law-fundamentals. Welcome to the Animal Law Podcast, Steve.
Thank you for inviting me.
I guess I should say welcome back, because we've been talking about your cases I think you were my very first guest. And so we have talked about these issues, but now they are really, really coming to the fore. And this case has really gone further than any of your other cases. And can you just start off by telling us, and it has to be brief because we don't have all the time in the world, even though we could talk about it for a long time, who Happy is and where she lives and why you consider her to be imprisoned and not simply cared for.
Happy is an Asian elephant. I think she's 50 or 51 years old. She's a she, and she's been imprisoned in the Bronx Zoo now for more than 44 decades. And she's generally by herself. She'd been by herself, I think, for about 10 years or so. And before then, she had been by herself at other times as well. And the reason we chose her is because we have brought in on our side probably the six of the greatest elephant experts around. So we speak to them, we talk to them about Happy, and it's unanimous that she is living a terrible life for an elephant. She lives in about 1 acre of land, and sometimes it's a lot less than 1 acre of land, and she's essentially by herself. And so that is about the worst life that an elephant could live, and that's what she's had to do for so long.
And if people are at all familiar with your work, and if they've listened to the prior episodes, they know that you are seeking a writ of habeas corpus. And everyone listening, I'm sure, has heard of it, but not everybody knows what it means. So just tell us really briefly what it is and what it does. And then we'll spend the rest of our time here kind of unpacking that and how it applies here.
A writ of habeas corpus, we get from England. And when I talk about we, since we're litigating it in New York right now, I'll just kind of everything I'll talk about is in New York. We've litigating in Connecticut, and we're about to file lawsuits in California, Colorado, Israel, India, perhaps Argentina, and we're working with Harvard to file an amicus brief in the Ecuador Constitutional Court that involves habeas corpus. So everything we do is habeas corpus, not just within the states, but actually throughout the world.
But coming back here, we're talking about New York.
That's right. We'll talk about that. New York habeas corpus, which actually is a general sort of habeas corpus. For certainly every English-speaking court understands habeas corpus, and not all other countries do, but many other countries who don't speak English still do. And it's something that we use for certain reasons. One is that the habeas corpus cause of action is a common law cause of action. And we think that that's very important for us because it does not involve courts trying to determine whether Happy is a person with rights under a statute or a constitution, but under common law. Should she have these sorts of rights? It's also something that moves very quickly. Oftentimes, it might move within 24 hours. You file suit, and it might move within 24 hours. In some states, it might go on for a month or 2 or 3 or longer. But in New York, it can go very fast. And one of our cases involving chimpanzee Tommy, if I remember correctly, the court ordered a hearing within 48 hours, which startled me because I was supposed to step on a plane the next day to fly to Sydney, Australia. So it had to be me asking if she'd be so kind as to give me 3 or 4 weeks when I was in Australia in order to come back and argue the habeas corpus. So it can move very fast. And it's also seen as something with respect to human beings to be very serious. That means that someone who's entitled to a right to bodily liberty is not getting their right to bodily liberty, and they're being held illegally. And it's also what occurred in the famous case of Somerset versus Stewart, which was decided on June 22nd, 1772, and essentially ended human slavery in England itself. And we actually use that as an example of how you bring a habeas corpus to try to end something like there it was human slavery, and here it's non-human slavery with respect to this specific elephant in New York.
Yeah, and I will just add briefly for people who are interested that that is the case that was formed the basis of your wonderful, wonderful book, which I highly recommend. Though the Heavens May Fall. Do I have that quote right? Yeah.
Yes.
Highly recommended. All right, back to the case. There are a lot of opportunities for procedural confusion here. And because there have been a number of different cases, and so rather than trying to lay out what happened in which case and who said what and what court said what, perhaps we can just say that in this particular case, the trial court and the appellate division, which for those outside New York is our mid-level appeals court in New York State, generally rejected your arguments by relying on decisions in all of your other New York cases, which, as you just mentioned, involved chimpanzees. And they had all ended unsuccessfully in the various appellate divisions. There are 4 appellate divisions. And so now you were in the Court of Appeals, which confusingly to the rest of the country is the highest court in the state of New York. And we should mention that the trial court in this case also, something that your opponents kind of left out of their brief, rejected your arguments very reluctantly, very, very thoughtful decision. So there's a lot in the past. I don't think we have to go into it all because we don't have that much time. And if anybody wants to go into it all, your website is unbelievable. It has every single document and decision that has ever been filed. So I highly encourage people to do, after they finish reading your book, they should go to your website. But all right, having said all of that, there is one decision from the past. We're just going to deal with them in the decisions in this case going forward. But there's one decision in the past that I really would like to mention just to set the scene. And that is Judge Fahey's concurrence. And Judge Fahey actually sits on the Court of Appeals. And so in that case, he was actually rejecting your petition to be heard in the Court of Appeals in that prior case, but purely on procedural grounds. And I feel that that decision in some ways set the stage for what is happening now. Do you agree? And if so, can you just kind of tell us what he had to say when he said in that prior case, you couldn't move forward to the Court of Appeals?
This has all been intended to do what we had to do. And we're still in the middle of it. It's behind me. I have about 150 books on human slavery and where it was and how it happened, and cases all over the world throughout the United States, and watched how long it took, what kind of arguments were made, how even judges who hated slavery still ruled in favor of slavery. So we always believed that something like this was going to happen, but you have to start somewhere at the beginning in order to get to the end you want to get to, because you're not going to start at the end. You're going to start at the beginning. And so one of the things was the first time that we went to the Court of Appeals, it just simply said no. So I think that was 2015. They said no, and they said no. And one of the issues is that in the state of New York, the Court of Appeals only takes about 3% of the folks who seek an appeal. So it's not easy to get there. But then the next case involved Judge Fahey. That was the third time, and the court again turned us down. But Judge Fahey turned us down because he thought, again, as you said, because of a procedural count, but he felt that perhaps for the first time that our merits were correct. And however, he was only one judge. And what we then did was bring the first elephant habeas corpus case anywhere in the world. And at that point, as you said, we lost in the lower court. But it's one thing that was really interesting, which in New York, if you're not in New York, that's the Supreme Court, is the lowest court. And so when we went into there, that judge did something that no one else had ever done. Most of our cases, our oral arguments could last 15 minutes or 30. One was 45. Justice Tuitt allowed us to argue for 13 hours over 3 days. And we always believed that the reason we were losing is that the judges simply didn't understand what we were saying because they were hearing it for the first time. When Justice Tuitt allowed us to argue for 13 hours over 3 days, if you read her opinion, you'll understand that she understood exactly what we were doing and was completely favorable to everything. And in fact, agreed with Judge Fahey and really thought that the elephant should have a writ of habeas corpus. But she felt that she was, as you noted, she was bound to a higher court in the third department, in the Lavery 1 case and in the Lavery 2 case in the first department, both of which are completely wrong. And she could understand that But she didn't have any choice because she was a lower Supreme Court justice, and so she had to do that. But you can see that she understands what we're doing. She agrees with what we're doing, but says, I'm bound by someone else. So that's when we lost in the first department.
The first department being you got Judge Tewitt's decision in the Supreme Court, which is the trial court in New York State. And then you went to the appellate division, and you went to the first department of the appellate division. There are 4 departments. It's a court where I happen to have used to work, but unfortunately don't anymore. Actually, maybe it's fortunate.
I wish you were there. You might be able to
Yeah, I doubt it would have made a difference, but I like to think so. Anyway, you went there. And that was the first appeal of Judge Tewitt's decision, who had agreed with you on the merits, but felt bound by precedent. First department could have differed. They were not bound by precedent, but they did not agree with your arguments.
That's right. They had, in an earlier case, in fact, the one that went up to Judge Fahey, they had essentially said that because our chimpanzee there, and likely our elephant now, because they weren't human beings, so they didn't have the right to habeas corpus. Almost everything they said was also wrong because they had relied upon the third department. Now, usually I don't say these sorts of things, but if I may just say for 1 minute, why these things were clearly wrong. There were 2 reasons. The third department in our first case, and then the first department, which was in our second case, both of them failed to go to the Court of Appeals. They were clearly wrong, and they were clearly wrong for 2 reasons. The first case was the Lavery 1 case, and we lost basically on 2 grounds. The first ground was that our chimpanzees could not engage in social contract, and in order for someone to have a right to be a person, you have to have the capacity. You had to be able to have rights and be able to exercise rights, but you also had to be able to have responsibilities. So you could have rights and responsibilities, yet you can have the capacity. In order to have a right, you had to be able not only to use rights, but you had to be able to have duties and responsibilities. And they're saying, well, your chimpanzees simply can't do that. And that's because the social contract required you to do so. In fact, they said that in order to win under social contract, you're going to have to be able to have rights and duties. And because that's how you make a social contract. What you do is you don't have any rights. You go to the government, you say, can we please have rights, and we'll obey certain things that you do. The problem with that is that is 180 degrees from what a social contract is. They simply misunderstood, did not understand at all what social contract was. It doesn't mean that you're not born with any rights and all the rights you get happen when you go to the government and they give you rights. What happens is that social contract says that you're born with zillions of natural rights. And if you wish to enter into a social contract and give some of those rights away in order to get other rights from the government, you can. But in theory, you wouldn't even have to join a social contract, but you'd still have all the rights that you were born with. So in other words, you have rights before you even enter into a social contract. Social contract doesn't give them to you.
In the case we're dealing with now, they don't even bother to argue the whole social contract theory, do they? It's really, actually the biggest argument they're relying on, and we can revisit the rights and duties. I do want to revisit that. But the biggest argument, I was so surprised by this looking at their brief, that they're really arguing, in some ways I understand it because it's the only argument they have left really when you think about it, that happy isn't human and only humans can be persons for the purpose of habeas corpus. Case closed. We don't have to think about it. We don't have to think about it. This is the way it is, that a person in the context of habeas corpus has to be a human being. So your whole raison d'etre for your life is to argue that a person, we don't define person just by the fact that somebody's a human being. And you argue that there are reasons to define somebody as a person, and they include autonomy and equality. And they just say, no, person means human. So can you explain how the common law allows you to argue that even though maybe nobody's ever said an animal was a person before, it allows you to argue that there are reasons for personhood under habeas corpus, and some animals, or maybe just one animal, like Happy, the animal who's at issue here, has those qualities. Why should autonomy be the basis for habeas as opposed to humanity?
Their brief also was extraordinary for us because the legal world is divided into entities who are things and entities are persons. One is either a thing or one is a person. If you're a thing, that means you lack the capacity for any kind of legal rights. If you're a person, then you have the capacity for rights. You might not have any, but you might have one or two, or or thousands of them. To our astonishment, the Bronx Zoo claimed that happy was not a thing, and they don't treat happy as a thing. And we sat there and thought, well, we finally agree that happy is not a thing. But what they don't seem to understand is that if you're not a thing, that means you're a person. So somehow it appears that we have agreed for our appeal that happy is not a thing and happy is a person. So they seem to have been surrendering there or giving in there, or it's really hard for us to understand that if they really think that happy is not a thing, then that should be the end of the case.
Isn't part of the problem the confusion between legal terminology and human speech? Like person, people use the term person to refer to human beings all the time and in common speech. But we all know that in law, it can mean something different depending on the situation.
We're talking lawyers from the other side who actually read our brief in which we explain in great detail why our client is a person and not a thing. And if you're a thing, you have no rights. If you're a person, you are. And their response is that the elephant is happy is not a thing. And both of us now agree that elephant's not a thing. There's only one thing that she can be, which is a person, which we find to be extraordinary, but thank you very much.
So there's a few things I want to unpack here. And one of them is that I think this is really important. You're arguing that she is a person for the purposes of habeas corpus. You're not saying she's not a person for other conditions or situations, but you don't have to argue that. You're arguing that she's a person because that's what's relevant here. But it is true that you can be a person for one purpose and not a person for another purpose. Is that right?
Yes, that is correct. In fact, you could theoretically be a person and have no rights at all. One of the things that we quoted to them, for example, was just at the beginning of the 19th century in the state of New York, they actually gave Black slaves like 2 or 3 rights. They could get married, they could have children, they could be prosecuted for crimes and have a jury trial, say, but that was pretty much it. So they are persons with like 3 measly rights, but one of them is not that they can't be someone else's property. That could occur in this case. That's another thing that they don't seem to comprehend, that it would be very possible for the Court of Appeals in this case. We talk about it, and we're going to be talking about it in our further argument in briefs, is that they could say that Happy has the right to bodily liberty, and she can come out of the zoo, and then they move her to a sanctuary. Well, theoretically, the Bronx Zoo could still be the owner, except they can't have the elephant there anymore. The elephant has to be at a sanctuary. I mean, that's a possibility that they could be. In fact, that might have just happened in the Tennessee Elephant Sanctuary last week, where Carol Buckley had been and started it, had her elephant Tara, and then she was fired from her job years ago, and she wasn't allowed to see her elephant. And it was just last week that she won. For 10, 15 years, the Tennessee Elephant Sanctuary, for example, had an elephant that someone else owned, and now she wants the elephant back. Now, the Bronx Zoo may not like the fact that they're still owning the elephant, but she can't live there. But that would be because of a court order, and they couldn't do anything about that. But being a person who has and people have property rights over you, there's an infinite number of rights you can have. All we're simply saying is this elephant, Happy, has the right to bodily liberty. And once you have any right of any kind, then at that point you are a person. However, we argue that she already is a person. In fact, there are many non-human animals who are, because in 1995, the legislature of the state of New York passed a pet trust statute. It allowed a number of different kinds of non-human animals to be beneficiaries of trusts. Now, someone who's the beneficiary of a trust has a right to the money that's in the trust. And so once they did that, that meant that the non-human animals who were subject to the pet trust were already persons. Now, we argue that Happy already is a person anyway, because she has the right to be a beneficiary. In fact, she's been a beneficiary of a trust that we made for her years ago. And that means that ever since 1995 time, when they passed the pet trust statute, the non-human animals who are under it were persons. We argue that Happy is a person, has one right, the right to be a beneficiary of a trust and the money in the trust. And we're asking for the second right, which is the right to bodily liberty. One interesting thing has been that, in bringing 8 cases in the state of New York and talking about the pet trust and writing about it and arguing about it, we've never had a single court who ever actually talks about it to us in the courtroom or writes about it, with the exception of one case where they just spent one line. It's not really clear what they're even saying. But we do the best we can to try to say, can we talk about the fact that Happy already is a person because she's a trust? We haven't had a single judge do that, which we find to be strange.
So let's talk about all right. So she is a person because she has at least one right. And then the number of rights that she can accumulate still has to be argued. And you are arguing that here, that she has the right to liberty, as you said, bodily liberty, and the right to equality. And can we just talk a little bit about that? Because, of course, autonomy is a fundamental argument for you in why she has these rights or should have these rights.
It's just one right. It's the right to bodily liberty that we make through a writ of habeas corpus.
Okay. So can you just explain a little bit about, I know this is a big question, but what autonomy means and why it leads to that right?
Okay, so we'll go down from 10 hours down to 5, down to 1, down to 10 minutes.
No, I need the really, really fast version, but we can't leave it out, Steve. We can't leave it out. It's the whole argument.
Justice Tuitt gave us 13 hours. That's when we were first time we were really able to succeed. But I understand that we don't have 13 hours today, so we'll just go down for a couple of minutes. Well, we argue that there's certain kinds of fundamental common law way. We're not so much saying that Happy has a right to equality. We're saying that that when you're trying to make a common law decision, then you use equality, liberty. I guess in some ways you can see that she has those rights. Sometimes they're just ways of looking at it. But we then talk about liberty and the fact that she has the scientific ability to have what would be counted in human beings in a second as liberty, and that equality the same way, in that whenever you're trying to determine what equality means, then you have to understand. Let me use humans first. You have to understand when one time there were white people and one time there were black people. Clearly, black people and white people were extraordinarily the same in thousands or millions of different ways. Their main way in which they weren't was their race, and so you had people who argued they should have rights because, as a matter of equality, they are virtually the same as a white person. But the white people there at that time would say, well, there is one difference, and that's race. Then you'd have a lot of these courts say, well, that's a difference that takes you out of equality. Now, we make a similar kind of argument in our case. There are many ways in which humans are the same and different. There are many ways in which elephants and humans are the same and different. What the other side can only say is, at one time, people said, you're not the same race. Now, all they can say is, we're not the same species. And we say, that means nothing at all. Who cares whether they're the same species? The question is who are elephants, and in what important ways are they the same as human beings? And we say, look at their autonomy, their general, enormously complex cognition, that we are so like human beings, and in a specific way that we're talking about, that they should have a right to bodily liberty, because a right to bodily liberty would allow them to lead this extraordinary life that they would if they were out in Africa, if they're or India when they were out in the wild. They have families. They can actually communicate with each other. They live these complex lives. And one thing that shows is we have the 6 best elephant experts, in the entire world, including people like Joyce Poole, Cynthia Moss, but 4 others. They're really extraordinary because we can prove that that's how they are. One really interesting thing is that the Bronx Zoo was unable to put a single elephant expert evidence in at all, because there isn't any elephant expert in the world who would say that our experts were wrong, or that an elephant should have to live essentially by herself on 1 acre of land rather than being rather than be somewhere else and live like they would in the wild. All they did was put in a few. The guy who runs the Bronx Zoo has a master's degree in biology, doesn't know anything about elephants, and 2 or 3 other folks who are way up there and don't know anything about Happy, don't know anything about elephants. They didn't put any experts in. And by the way, the Wildlife Conservation Society is the real fiend in this because they're the ones who are running the Bronx Zoo. Now, the Wildlife Conservation Society talks about how much they love animals. They have elephant experts. Of all the elephant experts they have, how many did they have to come in to tell us that our experts didn't know what they were talking about? 0. They had none.
That is an extraordinary fact. When I read that, I was blown away because presumably people who have expertise with animals have a real incentive to be friends with the Wildlife Conservation Society, which, is a hugely influential organization in this world. And yet they did not have one expert. All right. We've talked a bit about elephants, but I also want to talk a little bit about the common law and the way this intersects here, because I think that their argument, it seems to me, this argument that, well, you have to be human. You've always had to be human. That's the rule. That's the way it's written. That's exactly wrong about the common law because it isn't about the way it's written because it's not written. You're not arguing that it was ever intended that elephants are entitled to habeas corpus when somebody invented this writ, or that there's precedent for it. This is an issue of first impression. You're arguing really that the law should grow here. Isn't that right? And that common law is capable of adjusting. And I'll read out these principles, and I'm interested to know where they're derived from. Wisdom, justice, right, ethics, fairness, policy, shifting societal norms, and the surging reality of changed conditions. You say these are the situations that have been identified as why the common law should change. So where do these principles come from?
And we're not saying they're all of them. What we did was we went through New York Court of Appeals. And we looked at when they had dealt with arguments to change the common law and what they said they were relying upon. And so the 8 things that we set out, justice and wisdom and society and policy, and then for each one, we cited the Court of Appeals case in which they had said this is the thing that we would consider when we're deciding whether the common law should change. And then what we do in our argument is we go through each of those things. And we talk about why, justice on our side, policies on our side, social stuff is on our side. In fact, in all of them, we say that that's the reason why you should do that. And in some ways, that's what it was done. Because habeas corpus, when it was invented, which I think was around the 13th century, it wasn't thinking of including women or children or Black people or slaves. It just wasn't. But as centuries and decades went by, I think in the 17th century, you start finding the first cases involving a woman. In the 18th century, in the Somerset case, you find the first case involving a Black slave. And that's what we follow. I have the argument before us. Obviously, the amount of legal research and other kinds of historical research I did to write that book. I have everything that's ever been known about what was going on, in that case. And, it was utterly fascinating, how James Somerset's lawyers. And one thing that was very interesting about that was the fact that when I was researching, I was fooled for a good year because the fact that when I was reading all these transcripts, and there weren't many of them, but in the decisions, I couldn't really see that there were many lawyers involved, sometimes on neither side, sometimes only on one side, and hardly ever did the person who was trying to use it, have a lawyer. And then I finally realized that they just didn't. They couldn't afford it. They just didn't, or the courts didn't use it. This was the extraordinary time where there were 5 lawyers on James Somerset's side. 5, and I've never found anything more than 1, and that was fair. And even on the other side, there are 2, and usually there's only 1. So there you had 7 lawyers fighting about whether the writ of habeas corpus should allow a Black person to have the right to bodily liberty or to be free. And it was something that at the time was seen to be extraordinary, and the case itself within the United States and in anywhere you speak English was always seen as being this extraordinarily cognitively complex thing. And one of the terrific things was only a few years after the case was done, which was 4 to 5 years later, New York actually, in their constitution, they actually brought the Somerset case in, and they make it clear that the legislature, even if it wanted to do something to it, could not. It could make it easier and better, but it could not make it harder.
Yeah, really fascinating. And I don't want to go off on this, but I just think it's an interesting aside that this is really the first, maybe it's not, correct me if I'm wrong, but one of your issues has been that you haven't had like really big legal teams on the other side. And courts are not that comfortable with tackling huge questions unless they're getting all of the arguments and they really feel that the lawyers are making the arguments. So is this the case you were waiting for where like they were able to hire lawyers, like, and, expensive lawyers?
We found in New York that I think of the 8 cases, there were only 2 that brought in lawyers. The 6 that didn't, we lost. The 2 that did were the 2, once a chimpanzee, and once an elephant, in which once they brought them in, then we could move forward. By the way, what's going on now is enormous. People may or may not know. Amicus briefs are pouring in now.
Yeah, of course. I definitely want to ask you about the amicus briefs. I'm really excited about them. But let's talk a little bit more about the arguments before we get into that.
But I just say one thing, which is also a really strange argument that happened in Lavery 1 and has hurt us in other places as well. That, remember I told you about the social contract? That was number 1. Number 2 was the Third Department, which decided Lavery 1 actually followed Black's Law Dictionary's definition of person. And we were like amazed to read that. And they cited, this 50-year-old secondary book that was very well known. And that professor and judge there, and it was used all over the world, what he said was that in order to be a person, you only have to be able to have the capacity for rights or duties. But what blacks did, they wrote it down wrong, and they wrote rights and duties, and they used that against us. When we then went to, finally we found this thing from 1963, that it was actually even earlier, that blacks had used, we realized it didn't say you had to have rights and duties. It said rights or duties. Brian Gardner, who runs Blacks, we sent him an email saying, you got it wrong, and we're losing the case because Blacks has it wrong. And he wrote us back within 2 hours that day and said, sorry, we made a mistake. We'll fix it in the 11th edition. And they did. But meanwhile, nobody ever listens to what we're saying. They go back and they still cite Lavery 1, even though it got social contract wrong and it got the Black's Law Dictionary right, but blacks got it wrong. That's why we've lost.
Yeah, no, that I do feel in this case that they're not emphasizing that argument as much. I mean, I think one thing I noticed that they seem to be emphasizing as the cases develop and narrow, they do seem to be recognizing that some of their arguments are not that good and they're downplaying them a little bit. And another one that they made here, though actually I had not seen this argument before, maybe you had, was that Happy's conditions of confinement are not illegal, so they can't be contested by habeas corpus. But your whole argument is that they are illegal, right? This was inexplicable to me.
Yes, we're saying that they should have a common law right to bodily liberty, and that all of the experts come in to say this animal is being treated horribly, just horribly and terribly. The whole purpose is to use common law to begin to change that, to say we can look. The reason it's not legal, that it's not legal now, that they can say, is because they're saying they don't have any rights. I mean,
no, it's such a circular argument.
I mean, if I go up and I shot them in the head with a cannon, it may still not be illegal. I don't know. I mean, but they didn't have a right not to be shot in the head with a cannon. Maybe the state says, well, that's anti-cruelty and you're not supposed to do that. So it's a fight between me and the state of New York. But it's not a fight between me and the elephant. And what we're saying is the common law says they should have a right to bodily liberty. And now what you do, you take them out and put them in a place where they have bodily liberty.
I have sympathy for lawyers who are confronted with a common law case because, you hear about it in law school and then you never see it again for the rest of your life. But it's there, and they clearly don't get it. All right, another argument, and I don't want to skip this one because I think it's important. They also contend that habeas doesn't lie because she can't actually be released, but only transferred from one form of confinement to another. Why is that argument wrong? I mean, obviously, she's not going to walk out of the courthouse door and throw a party.
That doesn't make any sense. What happens if I'm kidnapped somewhere and they let me out? All I have is the earth now. I can't go through into the rest of the universe. Or maybe it's COVID and I can't leave the United States. So it's because I can't leave the United States, I have to stay in somebody's bedroom or something. It's the same thing. What you have now is that you have one acre at the most. You send them to either of the sanctuaries, they're averaging like 2,500 acres instead of living in a place. By the way, if you've ever seen an elephant in the wild, like I have when I went to Kenya, it's nothing. I mean, they move around. They have families. They live these incredibly complex lives. If you go down, go on, take the tram, go over, pay. I think they charge you like $40 or something, which I wonder if that's any reason why they're using, why they have Happy. You look down, you have a 50-year-old elephant standing there, not moving, standing there. This is a severely, terribly treated, depressed, screwed up elephant that our experts also say, give us examples where they'll take an elephant like that out and put them into a good sanctuary. And then all of a sudden, if you go to the Tennessee Elephant Sanctuary, or you go to the Paws in California, there's there's streams, there's friends, there's like grass, there's forests. I mean, they're not in Africa, but when you're in 2,500 acres and you're out in nature, their life is way different. And they wouldn't be standing there watching you come over their heads.
Yeah, it just seems so obvious that they're also saying that it's not up to you to choose where this elephant would go. But you're not even saying that, are you? You're making suggestions as to this is the best option for this elephant. And it's up to the court really to decide where the elephant goes, right?
That's exactly right.
Yeah, I just feel like they're saying that you're putting yourselves in charge and you're just asking for something. I mean, the court may not know about what elephant sanctuaries are available in this country. It's just possible. That's not common knowledge.
Well, they're really nice places. If you're an elephant, you can go there. But the great thing is, if you're not an elephant, you can't go there. They're done with human beings, except the small number of them who are taking care of them. We're not asking to own them. We're not asking anyway. We're not doing anything. We're simply saying we want you to issue the common law writ of habeas corpus, and we use the common law writ of habeas corpus to issue the right of bodily liberty. And then we specifically say at that point you should send that back to the Supreme Court, who then decides where the elephant goes and who owns the elephant. So in fact, we say they go to one of the two sanctuaries, and you could either say that one of them owns the elephant. You could say that the Bronx Zoo owns the elephant, or you can say that the elephant owns herself and isn't owned by anybody.
That would be sweet. That would be sweet. But ownership is not really the issue that you're litigating here. I think it's important to make clear, because obviously that's an issue that comes up.
We don't argue anything about ownership except to say, would you please stop talking about it? Because no, we're not.
All right. This is one more argument that really, I thought it was crazy. Maybe I'm wrong. They make this argument that Happy should be denied habeas corpus because you don't set forth clear guidance as to when habeas corpus would be allowed for animals in the future. And obviously this is a very big, it's clear that there is an issue going on here. But is that really your obligation to set forth how the entire world will work? Or are you just litigating a case? And am I answering your question for you? Take over. Take it out of my hands, Steve. Take it out of my hands.
All I'm saying is that an elephant, has these extraordinary, complex cognitive abilities that are virtually like a human. In fact, after the 13 hours of argument to the Supreme Court, she said the elephants were just like a human, and they're so much like humans. And we're simply saying that if you're like that, that is a sufficient ground for habeas corpus. We don't argue what a necessary ground is. We don't need to. We're just saying that if you are like a human in ways that are important at all, would be to humans, and they're important to the elephants, and they can live these extraordinarily cognitively complex lives because they have extraordinarily cognitively complex minds, then that's a sufficient ground. That's all we're saying. And by the way, that's what you do in common law. You don't make all these major grounds. You simply say, okay, we'll do that. And if someone wants to do something else, well, then someday they'll bring another hearing in. And they can't be, they only take 3% of the cases that go in front of them. So if they don't want to take another one, well, they don't have to.
Yeah. You're not passing a statute here. You're not setting rules for the entire world. You're arguing what should happen to Happy.
Which is really strange, because they want us to have to go into the legislature. And actually, they're the ones who'd have to make kind of specific rules. We're actually making it less good for non-human animals by going through habeas corpus, because it's just one animal going up one time. We're not going in and asking that all animals or all elephants or whatever, or all any kind of animal have a right. We're just taking them case by case by case and see what happens.
So it's kind of related to a floodgates argument, which I think a floodgates argument is almost always wrong. It's usually an argument about, or slippery slope arguments. I hate those arguments. It's usually an argument about why we shouldn't do the right thing here because we'll end up doing the wrong thing later. And that's not I find that a dreadful argument, but it is kind of compelling.
If I may say that the Court of Appeals in New York, and especially in a case of like Tobin versus Grossman, said that we don't accept that. We simply won't. We're going to look at each time, and we're not going to feel that we're somehow terribly bound by what occurred before us.
But as you were saying, they do argue. I mean, this is the argument that underlies all of their other arguments. It's the one they really want to get across, and that is the one you just pointed out, that this is a matter for the legislature. I mean, what is wrong with that argument?
The legislature is allowed to do something, but so is the Court of Appeals. And in fact, what's so extraordinary, and this may be the only cause of action in New York, is that the legislature can do just about everything. But under the New York Constitution says that the legislature may only do better things for habeas corpus, not rather than worse things. So we already have the minimum that the legislature would have to do, and that the court would do. It's a common law issue. And it's always been a common law issue, and it's not a statutory issue. At least the fact that it exists and there's certain important things under the habeas corpus are there. The legislature can never do anything about it. But the thing is, you already have rules that say when you can use it, and you can always use it, and you should use it now.
You could kind of use that argument in any case in the courts in which there isn't like just a completely direct binding precedent. Like you could say, well, it's new, so it's a new wrinkle on this issue, so the legislature should decide. But that's not what the courts do. I mean, the courts decide things, and you've asked them to decide something.
Well, if something's in common law, what we try to explain to the judge is that common law means you, judge, and it doesn't mean the legislature. And it's kind of embarrassing for me sometimes to have to argue to the judge that that's how the common law works.
I know, like I said before, like you hear about the common law in law school, and you may hear about it every day, but the rest of us, not so much. All right. You mentioned before how excited you are about the amicus briefs. So tell us about them.
Well, they're coming, which we think is great. So right now, there have been 9 briefs filed that have been signed by a total of exactly 70 people. Let's see if I can remember who they are. And some of them they knew, some of them we don't even know. Last week, 3 Buddhist scholars filed saying under the Buddhist religion, happy should be let free. Catholic theologians did too. We've heard, and I don't even know who they are, that Jewish folks are doing it, Protestant folks are doing it. We have 4 of the amicus briefs when they finish, and we don't know when that will be or who's filing. You had a Cameron, who was a judge that Mandela put on the Supreme Court of South Africa. He filed an amicus brief. You had Lawrence Tribe just did on Friday with 2 great professors from Cornell Law School. We've had 36 people, lawyers and profs, just filed it from England. We think there's going to be a similar number filing it from the United States.
Martha Nussbaum. I was so excited when I saw that.
Martha Nussbaum filed one. Christine Korsgaard, who's a terrific philosopher from Harvard.
2 incredibly thoughtful, important people.
The philosophers, the 14 philosophers. Let's see. The Catholic, the habeas corpus scholars, including 4 of them who were involved in the black kids who were wrongly charged in Central Park in New York. They worked on habeas corpus. So, and there's more. There's 9 of them. We think more are coming in. We don't know. We're not the lawyers for any of them. Did
anything that they argued surprise you?
Well, yes, for interesting reasons. Like on one day I'm reading the Buddhists, then I read the Catholics. Someday I'll probably read the Jews, in fact, I think Jews may have filed in the first department. I can't remember now. They all give different sorts of reasons. Some of them talk about the Old Testament and New Testament. Some of them talk about Buddha. They all agree. One, I haven't read the Tribe brief yet, but I think it's extraordinary. Interesting. It had 47 footnotes. The UK one was incredibly fascinating. 121 footnotes, which I'm reading. But what was extraordinary, and I have to confess, one of the amazing things that they did is they actually found a statute as to how you interpret something, whether you use or and, that we never knew New York had. And they found it, and right, you never heard about it either. There's actually a statute that talks about how you might interpret and or when something requires and or, because and could be an or could be and. And I'm saying, you got to be kidding me. There was a statute like that. We were amazed. And then a lot of them are filing things that are really big in philosophy. And the question is it beginning to move towards law? So we're going to probably talk more philosophy, but in a legal way than we used to. And so some of the really good lawyers are now also already bringing, and so are the philosophers, they're bringing philosophy in as to why the law should do it. So that is like extraordinary for us. And I mean, we don't know who else is coming in, but from the rumors we hear, we might not even be at the halfway point. Also, really interestingly, so far, there have been 3 people who filed for the Bronx Zoo, which was great. If they want to have 20 plaintiffs come in, we're ready to fight anybody. And one of them was the same people who went into court as an amicus, which was very funny, claiming that if we got Happy out, that means we would destroy the New York dairy industry. And so if that's the judge didn't really seem to buy that.
Could you make that true? I guess not
about that right now at all. So and then they had 2 other ones, 2 huge organizations who are not even 501c3s. They're 501(c)s. The object for them is to make money. So you had the National Association of Biomedical Research.
Of course.
Oh my God! If an elephant gets out and goes there, who knows? You won't be able to do research. And then the other one was the American Veterinary Medical Association. By the way, if I may say something, Kathleen Sullivan, did you read what I wrote about Kathleen Sullivan?
No, I mean, I know her name, but I don't know a lot about her.
She's extraordinary, and she's a civil rights lawyer. So what I did is I wrote something called Moving from a Bigot to a Hero and a Hero to a Bigot. And I talked about this one Massachusetts lawyer in the 1830s who argued that Massachusetts should have slaves. He lost unanimously in the Supreme Judicial Court. 15 years later, he went to the U.S. Supreme Court. And then he was actually one of only 2 judges who voted against the Dred Scott case, and was so angry about he became the one and still the only Supreme Court justice who resigned from the court because he thought that's a matter of principle. And I said he was a person who was a bigot who then became a hero. Kathleen Sullivan, the cases she's done have been unbelievable. She even did with Larry Tribe the first the 1985 case where being gay or doing gay rights could be made illegal. And then she actually files the National Association for Biomedical Research and says like the most bizarre things, and also makes the same mistake with blacks, leaves out the part that says, by the way, you don't have to be a human being in order to do that. So I wrote something saying the guy from 1837 who then went on to the Supreme Court, he went from being a bigot to a hero, and Kathleen Sullivan went from being a hero to a bigot by not using any of the language she did when she cared about gay people, when she cared about Mexicans or Puerto Ricans. And instead, she started using the exact same arguments that slave owners always use when they're trying to get at the slaves.
Wow. That's a really interesting story. And it really does show. I mean, I think reading your papers in this case too, like, because as we said, you did have like competent lawyers opposing you now, and their arguments, they're starting to recognize that their arguments, like, they're inconsistent, they don't hold water, they're just relying on arguments that are just very pro forma.
They're bigots. They're relying on people being bigots.
Yeah. Because when you start applying these general principles to elephants, it's really hard to draw that line unless you just say it's just humans. That's it. It's just humans.
And right now we already have Buddhists and Catholics say, by the way, you're violating God's
yeah.
rules.
Well, one thing I love about that part of the story is that this is one of the things, maybe one of the only things, that is starting to make people of religious persuasion think seriously about this issue, which they have just taken this huge moral issue, which religions have taken a pass on, just ignored for so long. And you're kind of bringing them out and You're not forcing them to take a position, but you're at least getting them to take a position. And that kind of brings up the whole bigger issue. Like, I know you want to and you expect to win, but I would like to talk a minute about the impact your cases are having, regardless of whether you win or lose, in kind of the cultural conversation, not just on the religious front, but on the whole way the world talks about animals. And do you find, as you move forward with what really is a heroic quest, I mean, I have found this in the articles that are written about your work, that people are starting to think more seriously about animals as a result. Is that one of your goals here?
That is actually our goal. The goal is to begin having people talk about these things, and to begin to understand it, begin to understand, for example, with an elephant, who an elephant is. The zoo says, oh, it's so wonderful to bring children into the zoo. They get to see animals. We'll say, they don't know anything about what's inside the elephant's brain. They don't know anything about it. All they're doing is looking at a big being. It's really one of the many crazy things that they do. But obviously, we hope to win. But whether we win or whether we lost doesn't matter that much to us, because what we're doing is we're trying to win on a large level, because we're going to be saying in California and Colorado, we could lose in one state and win another state, or could lose in all or win in all. Or it's again, I take the slavery cases very seriously, because as I watched how they'd go in all the various states in all the various countries, and we think the major victory that we've had is on the fourth time the Court of Appeals in New York takes our case, and we get to come on wonderful shows like yours and say what we're saying.
I would have had you on even if they'd rejected you, Steve.
Last week we were on the article in Time Magazine,
an equivalent outlet to our Hen House.
It's not as good as Hen House, and also, I'm talking to a person who's writing an article in Atlantic Magazine. I'm talking to another one who's writing an article in New Yorker.
You have consistently gotten extraordinary press for your work, consistently, and very little is more important than that.
Well, that's the whole purpose of it, is for people to begin to think about it, to understand why our arguments are correct. And at first, they just try to say things that are not correct. They're wrong. But eventually, I mean, if you just come in, frankly, we are the only true animal rights organization in the United States. People use the word animal rights all the time, but what they're really dealing with is either one thing, they're either dealing with animal welfare or protection, calling it animal rights, or you might be an organization that once every 5 years might want to bring a case and they lose, but that you never hear it about again. Everything we do, we bring every case because we decided we want to do it as the next step to do this and the next step to do this. And it's a plan that we're now in year, 10 of that. And we have near 20, 30, 40. We understand exactly what it is we're doing. And so far, we're actually moving more quickly than we thought we would.
Things really have taken off. I mean, reading Judge Fahey's concurrence was an extraordinary moment for me.
When there has been a kind of legal bigotry that is now more than 2,000 years old, like it was with being a human slave. I mean, we're not planning on making it as slow as it was for humans. But if you think you're going to win when you start, well, you ain't. But eventually, when you have the right answers, and we do have the right answers, and the other side doesn't have the right answers, except basically plead to the judges to use their bigotry in favor of towards humans and bigotry against our client, whoever they are, they can win on that for some time. And then I think there'll be some time in which they're the majority and our arguments are the dissent. And then where ours becomes that way and theirs become a dissent, and then ours eventually begins winning, because people understand that that's what you have to do. If you want to have a law that is equal and touts liberty, then you have to do what we're asking to do. And we're not being particularly hard. We're saying when you imprison an animal, that it's like torture for them for their entire lives, and we can prove they have these incredibly concentrated, complex, powerful cognitive abilities, then you have to pay attention to those and you have to do something for them. Because once you decide you don't have to be good, you don't have to be right, you don't have to be just for reasons that don't make any sense, then that's the way you creep back towards having the same problems happen with human beings.
Yeah, though that's not the only reason to do it, because everything you're doing matters so much, and just getting people to think about this in a serious way. And the wonderful thing about the law is that forcing these courts to write down their reasons, which then you can look at them and say, this makes no sense whatsoever. this would mean that cognitively impaired people are not entitled to freedom. This would mean that children can't ever get habeas because you can't let them out on the street. I mean, like their reasons end up being, when you force people to write down why they believe something when it has anything to do with animals, inevitably it usually ends up completely wrong. And when you can read it right there in black and white, you can say, well, this is wrong. What happens next?
The Court of Appeals is going to tell us when oral argument is. We actually filed a motion asking if they'd be so kind to have it in 2021, and they denied our motion. So it's not happening in 2021, and it'll happen in 2022. We'll probably get about 2 months notice. My guess, if they can, I think every seat in the Court of Appeals courtroom is going to be taken up. We have people all the time who say, we want to televise this. I say, okay, well, we were not involved in that. If you want to go ahead and try it. We have people who contact us, all over the world all the time. And that's why, we're working in India. There's one in Israel. Folks in Malaysia, we're talking to, Argentina, Ecuador, there's people all over the world who want to talk to us about it. And we're saying, and in fact, if we can figure out a way of having you win, but we can't win in a state or in the country, that's okay with us. Because eventually what's good in the US will become good elsewhere. What's good elsewhere will become good in the United States. So the important thing is to move justice for non-human animals anywhere that we can help them, others get that done, while we're trying to do it for the cases that we're involved in as well.
Yeah, so inspiring, Steve. Thank you so much for changing the whole world of animal law. I mean, we've known each other for many, many years, and your work has been always one of the most vibrant and exciting and meaningful parts of caring about animals, and gives us a little hope every once in a while, which is a hard commodity to come by in this world. So thank you. And thanks for joining us today. It's been great. Is there anything I should have asked you that I did not?
No, actually, the only thing I was going to say there was in 1985, I was living in Boston, and I wrote all 5 law schools if I could teach a case in animal law, and none of them even responded to me. Now I've taught at 9 law schools, including Harvard and Stanford. And so to me, that's an example of where we're moving.
We can't ignore the progress, and a lot of it is because of you.
Well, you're very kind.
Thank you so much for joining us on the Animal Law Podcast. We'll be back next month with a new show. And thank you so much to Steve for taking the time out of his incredibly busy schedule to tell us about this extraordinary case. Also, thank you to Jen Riley for her help in producing this podcast. If you're not already a subscriber, please consider doing so wherever you listen to podcasts. Consider leaving us a good review there or on Apple Podcasts. And if you're able, please consider making a tax-deductible donation at ourhenhouse.org, especially now, between now and the end of the year, so we can make our match. And thank you so much for tuning in.